Seatac. It's a great pleasure to be the host today. Seatac Live is a live stream platform set up in 2020, right after the outbreak of the COVID-19. It is to fulfill the function of communication, education, and exchange of ideas on hot and major issues in law and arbitration. Ever since its launching, the Seatac Live has presented over 30 well-received lectures and dialogues, including the Civil Code of China serial lectures and the Master's serial lecture. Recently, we just concluded a serial dialogue on sports-related dispute resolution for the occasion of the Winter Olympic Games in Beijing. But it has attracted 0.3 million visits to our broadcasting. This series is called International Arbitration Insight Series. It is co-organized by Seatac, Wolters Kluwer, and IDRA. So following, I will invite Ms. Gwen de Vries, Director of Content and Market Development at Wolters Kluwer, to give us the welcome speech. Gwen actually has decades of experience and expertise in information services, focusing on the international legal market, including international arbitration. Among other projects, Gwen leads the team behind Kluwer Arbitration, Wolters Kluwer's development of content for expert solutions and practical digital tools. She oversees Wolters Kluwer's publication of the dozens of international arbitration-related books and journals in both digital and print format. She developed the Kluwer Arbitration CD-ROM, the predecessor of the Kluwer Arbitration website, and also helped to conceive and establish the Kluwer Arbitration blog. Now let's invite Gwen, please.
Hello, I'm going to share my screen. If this works. Yeah, Ms. Shi from the Seatac Arbitration Court, thank you for inviting me to speak some opening words for this new series of Seatac Live webinars, and welcome to all speakers and participants. This is another episode in this International Arbitration Insight series. It's organized, as already mentioned, by Seatac, Kluwer, and IDRA, and supported by Stevenson & Harwood, Yink Global, Kingwood & Mallesons, and Han Kuhn Law offices. The series of events aims at sharing practical insights on the most important topics in the arbitration process by top arbitration lawyers. It's inspired by the new module, Kluwer Arbitration Practice Plus on Kluwer Arbitration, and in particular, the practical insights topics. The moderators and some of the speakers later today are editors and authors of this important new module on Kluwer Arbitration. And yeah, at Kluwer, we're quite proud of this new module that recently won the Gold Stevie American Business Award in the category Legal Information Solutions. Please give me a few minutes of your time to give you a flavor of this important new module. Kluwer Arbitration Practice Plus consists of practical tools that provide support throughout the arbitration process. It's fully integrated with the market-leading research service, Kluwer Arbitration. The practical insights cover the most pressing, challenging, and hot issues in the international arbitration process, from interim measures to enforcements. And at the beginning of 2022, we had around 40 topics, and we expect to complete this feature and reach some 55 topics at the end of 2022. Each topic delivers actionable insights for key decisions in the arbitration process, and it will drive efficiency, mitigate risk, and optimize case strategy. Here you can see one of the topics on anti-arbitration injunctions. Each topic follows the same structure.
And we don't see the slides, Gwen.
Oh, how come? Okay. This is. Do you see it now? Share. Do you see it now? Yes? Okay, I'm very sorry about this.
Yes.
I won't start all over again. So here you see one of the topics on anti-arbitration injunctions, and each topic follows the same structure. An introduction to sum up the topic, in a nutshell, to help orientate and introduce less experienced readers to the subject matter, and to remind more experienced readers of key points and emerging trends. Also important considerations that highlight the most important practical guidance, including potential pitfalls and main points, decision points for parties. Next slide shows you the practical steps. This provides the most important points and steps when it comes to taking action, including links to sample documents as appropriate, depending on the topic, but also suggested reading with key cases, commentary, and blog posts for further study. And then finally, the comparative notes that follow is again a set structure and that will empower parties choosing among institutions or seats of arbitration to make an informed choice. And second, to equip parties with the knowledge needed to work within institution rules or at a seat of arbitration that have already been chosen. Each topic has 15 jurisdictions and 15 institutions, including the most important ones. Now we have a highly qualified editorial team, and again, some of them are here today. 4 editors, of which some are present today, and more than 60 authors, and also some of them are presenters today. We're very grateful for the excellent contributions that they provide. Then, very briefly, the other feature of Kluwer Arbitration Practice Plus, and that's the enhanced Arbitrator tool. And for this tool, we gather the available appointment data and awards from trusted sources. We use machine learning technology to analyze the data and provide content enrichment suggestions. It was a big effort. A team of subject matter experts confirmed or corrected these suggestions, and then the enriched content was transformed into tools. Our arbitrator profiles are now a mix of self-reported and data-driven information. They provide all kinds of interesting analysis, for instance, on expertise with specific sectors or institutions or applicable treaties. And we link the profiles to more than 5,000 awards and publications in Kluwer arbitration. And finally, we set up a relationship indicator that establishes relationships between people, firms and parties, and uncovers potential conflicts of interest. Now, I've come to the end of my presentation and a brief tour of Kluwer Arbitration Practice Plus. It's a shame that you couldn't see everything, but the slides are there. For more information, please don't hesitate to reach out to me. Contact the link on the slides or representative if you already subscribed to Kluwer Arbitration. It's a great pleasure to now open these new International Arbitration Insights series, organized by Seatac, Kluwer, IDRA, and supported by Stevenson and Harwood, Yinke Global, King, Wood and Mellison's, and Han Koon Law offices. Thank you.
Thank you, Gwen, for the thorough introduction of what is going on with Kluwer. Following, the next speaker will be Madam Changchin, the Vice President of the Arbitration Court of Seatac. Madam Xie has 30 years rich experience in the area of professional commercial dispute resolution, either as the assistant to the arbitral tribunal or as the arbitrators. She is an arbitrator on the panel of many renowned arbitration institutions. Before the present position, starting from 2021, she had been working on the position of Secretary General of Seatac and the CMAC Tianjin Subcommission, and served as the Vice Secretary General of CMAC for many years. Now let's welcome Madam Xie to deliver the opening speech.
Dear Ms. Vries, ladies and gentlemen, it's my great pleasure to join the experts and friends from out of the world online to witness the opening of International Arbitration Insights, Series 2022. On behalf of Seatac, I express my sincere gratitude to our co-organizers, Waters Kluwer, IDRA, and our supporting law firms, Yinke Global, Stevenson Harwood, King & Wood Mellison's, and Han Koon Law offices for making this event happen. Seatac is one of the leading permanent arbitration institutions in the world. Throughout its over 60 years of history, Seatac has accepted over 50,000 arbitration cases. For decades, Seatac has been standing for the international brand of Chinese arbitration and also Chinese experience of international arbitration. This is echoed by International Arbitration Survey released by Queen Mary University of London and White and Case LLP in 2021, where Seatac ranked among the 5 most preferred arbitration institutions in the world. Such popularity and reputation are tested and proven by the cases we handle. In 2021 alone, even under the impact of epidemic, the work of Seatac saw a new breakthrough. Seatac accepted 4,071 new cases last year, with a total amount in dispute of RMB 123 billion, exceeding 100 billion for 4 consecutive years. Among the cases, 636 were foreign-related, involving 93 countries and regions, and there were 61 cases where both sides were non-mainland China parties. In addition, Seatac has become more technology-driven and user-friendly. Last year, 870 cases were filed online, and 434 hearings were conducted virtually. The statistics took a definite lead among arbitration institutions in Asia-Pacific region and even in the world. Ladies and gentlemen, this year's lecture series will include 4 hot issues in international arbitration, and Seatac is highly experienced in many aspects of them. Seatac present arbitration rules have provisions on both joinder and consolidation, which have been successfully applied to many cases. Although the conduct of the procedures may indeed bring procedural delay or dissents in a small number of cases, generally it's deemed to have played an active role in improving efficiency, saving cost, and reducing the risk of inconsistent arbitral awards rendered by different tribunals. Seatac provisions in this regard are basically consistent with the general practice of international practice, but also have its own characteristics, which I believe my colleagues from Hong Kong Center and the speakers from Inca Global will soon share with you in detail. Besides, I'd like to take the opportunity to mention Seatac's another procedure, which plays a similar function to joinder and consolidation. That is multiple contracts. In this regard, Seatac has already accumulated a lot of experience, and it's highly suggested to initiate a single arbitration case based on multiple contracts from the very start of arbitration. Statistics show that in the year of 2021, among the cases accepted, there were 579 cases involving multiple contracts, accounting for 15% of the caseload. Concerning the topic of evidence, in 2015, Seatac released guidelines on evidence in accordance with Chinese law and also with appropriate reference to the general international practice, particularly the IBA rules on the taking of evidence. The application of the guidelines is subject to the parties' consent or agreement in each case. As to evidential disclosure and privileges, due to different law condition and practice, the procedures seldom appear at Seatac's domestic arbitration, which really makes Seatac arbitration very efficient. But if one party requests it, the tribunal may decide whether to agree to the request and extent of disclosure, having regards to the circumstances of the case. I understand how much you expect our speakers to start sharing their insightful thoughts. To conclude my remarks, I thank all the organizers, speakers, and participants for your great support and wish today's and also the following events a complete success. Thank you.
Thank you, Madam Xie. As Madam Xie pointed out, all the topics of this International Arbitration Insight series are very practical issues which can be frequently encountered in real arbitration proceedings. Today is the first episode of the series focusing on joinder and consolidation. So without further ado, let's enter into the roundtable discussion. The first session is on joinder and non-signatory parties. The moderator of this session is Mr. Andrew Ritgen-Green, partner of Stephenson Harwood. Andrew is a specialist in marine and international trade matters, including shipbuilding and construction, installation and operation of offshore structures. He's an expert in arbitration, litigation, and mediation, and he's the head of the Marine and International Trade Team in Hong Kong. He has represented clients in English and Hong Kong High Courts and Courts of Appeal in arbitrations in London, Hong Kong, and has conducted numerous mediations. He's familiar with the practice of many different arbitration institutions. So Andrew, I will leave the introduction of the speakers of the first session to your hands.
Thank you very much, Lu Fei. It's an absolute delight for Stephenson Harwood to join together with Seatac, Wolters Kluwer, the IDRA, and collaborate with Yinka in delivering this session on joinder and consolidation in arbitration context. Arbitration, as we know, is all about contract, and arbitration must be conducted within the four corners of an arbitration agreement. But frequently, there are situations where there are multiple contracts or multiple connected contracts, or situations where it would be useful to have the third party joined to an arbitration in order to streamline the dispute. That kind of procedure would alleviate the risk of multiple legal actions, inconsistent awards and findings. But it poses a massive challenge to arbitration tribunals because they must balance the scales of convenience against autonomy of the parties and choice of arbitration. Joinder of non-signatories is indeed a difficult subject. And so I'm absolutely delighted to be joined today by four leading specialists in arbitration. Firstly, we have Professor Bernard Hanotio. Professor Hanotio is Professor Emeritus at the University of Louvain in Belgium and visiting professor at the University of Singapore. He's a partner in the law firm of Hanotio and Vandenberg, and since 1978 has been involved in more than 600 arbitrations in all parts of the world. He's the author of Complex Arbitrations, Multi-Party, Multi-Contract, and Multi-Issues, published by Kluwer. In addition, we'll be joined by Kieran Gore. Kieran Gore is one of the executive editors of Kluwer Arbitration Practice Plus, and her practice focuses on all aspects of US and transnational dispute resolution. She is a professorial lecturer in law at the George Washington University Law School, and draws on her professional experience acting as co-editor. And then we're also delighted to be joined by two practicing lawyers from Yinka law firm, Yang Linda, who is the executive chairwoman and global partner of Yinke Global. She is a specialist in corporate and commercial law and has acted for mainland and international parties in all manner of dispute resolution and contract negotiations. We'll also be joined by Huang Shihan, who has been working with Beijing Yinke law firm since 2013, and he focuses on foreign-related legal affairs. He has a lot of experience in both non-contentious and contentious matters. So without further ado, I will hand over to Professor Hanutio. Just a quick note, Professor Hanutio is sitting as an arbitrator this morning in Paris, so he may have to leave us early from the session, but we are delighted to have you, Professor, and we look forward to hearing from you.
Thank you very much, Andrew. Dear colleagues, I'm extremely pleased and honored to be speaker in this seminar devoted to joinder and consolidation. In fact, one of my greatest experiences in my career is precisely a consolidated case involving Chinese companies, which I presided in Stockholm, the well-known Wahaha arbitration, in which we had a de facto consolidation of 8 arbitrations involving different companies belonging to a French group on one side and 8 companies of a Chinese group on the other side. We had a 6-week hearing. The parties were represented altogether by 45 lawyers, and we delivered 8 awards totaling 4,500 pages. My topic today is non-signatories in international arbitration. Let me start with 2 preliminary remarks. The first one, it is not because you have signed a contract containing an arbitration clause that you will be a party to the arbitration procedure when a dispute arises. You may indeed have signed the contract in your capacity of representative of one of the companies involved, and it is that company that will be the party to the arbitration when a dispute arises. And conversely, it is not because you have not materially signed the contract containing the arbitration clause that you are not party to that contract and its arbitration agreement. I will develop this point later. In other words, the signature on a contract containing an arbitration clause is not the decisive element when the question arises, who are the parties to the relevant arbitration clause? I turn to my second preliminary remark. Reference is often made in the literature to the notion of extension, quote unquote, of an arbitration clause to a non-signatory. To a large extent, this wording is incorrect. You do not generally extend an arbitration clause to a non-signatory. You determine the scope ratione personae of the arbitration agreement, and you eventually reach the conclusion that this scope includes the non-signatory. On what basis? Well, on the basis of a series of theories on which I will say a word: agency and representation, third-party beneficiary, incorporation by reference, individual or universal transfer, community of rights and obligations, estoppel, alter ego, and piercing the corporate veil. And the last theory, which is very important, implied consent. The first theory to bind a non-signatory is agency or representation. If A signs a contract containing an arbitration clause, but is only representing B, the party to be sued in arbitration if a dispute arises, is not A, but B, the non-signatory principal. The second theory is third-party beneficiary. If a contract, for example, a life insurance contract, provides benefits to a third party, it appears to be a fundamental principle that this third-party beneficiary, that if this third-party beneficiary wishes to benefit from the rights it has been conferred by the contract, it must also assume the obligations thereunder, and in particular, the obligation to arbitrate any dispute arising thereunder. And the same applies if one of the parties to the contract wants to start an action against the third-party beneficiary non-signatory of the agreement, it must do so under the arbitration clause contained in the contract. The third theory on the basis of which an arbitration clause can be quote unquote extended to a non-signatory is the theory of individual or universal transfer. This is a very broad theory. It applies, for example, in case of transfer of contract. If A and B, signatories of an agreement, transfer that agreement to C, non-signatory, will be the new party to the contract and its arbitration clause. This will also be the case of the non-signatory heirs in case of succession. It will also be the case of the transferees of a debt, or the case of the third party subrogated in the rights of a signatory to an agreement containing an arbitration clause. In China, the principle is included in Article 8 of the interpretation of the Supreme People's Court concerning some issues on application of the arbitration law of the PRC. It provides that, and I quote, where a party concerned is merged or divided after concluding an agreement for arbitration, the agreement for arbitration shall be binding upon the successor of its rights and obligations. Where a party concerned has died after concluding an agreement for arbitration, the agreement for arbitration shall be binding upon the inheritor who inherits his rights and obligations in the matter to be arbitrated. And for the transferees of a contract or a debt, Article 9 further provides that, and I quote, where the credits or debts are entirely or partially assigned, the agreement for arbitration shall be binding upon the assignee unless the parties concerned have otherwise agreed or the assignee explicitly objects to the assignment of the credits or debts or does not know there is a separate agreement for arbitration. The fourth theory is Estoppel. It is mainly applied in the United States, and since we do not have much time, I will not address it. The fifth theory is incorporation by reference. This is the scenario where an arbitration clause contained in a contract between A and B is incorporated by reference in another agreement, for example, a guarantee agreement concluded between B, signatory, and C, non-signatory to the first agreement. I have read that in China, the law allows the incorporation of an arbitration by reference to another contract, including the arbitration clause, in circumstances where the terms were readily available to the parties, including the non-signatory, and the arbitration clause was clear and obvious from the referred contract. The sixth theory is community of rights and obligations. A common scenario in this respect is where a commercial contract is concluded between a company and a state entity, both signatories, but the contract contains obligations which can only be performed by the state to which the state entity belongs. In case of dispute, the arbitration will be frequently initiated, not only against the state entity signatory, but also against the state non-signatory. And the tribunal will often determine that it has also jurisdiction over the state non-signatory, given that the state has impliedly accepted to perform certain obligations under the contract that it has not formally signed. The seventh theory is alter ego and piercing the corporate veil, two theories which are closely related. Alter ego is mainly an American theory, although it is also applied in other countries. It permits, for example, to extend, quote unquote, to to extend an arbitration clause to the non-signatory owner of a company which itself is signatory of the contract containing the arbitration clause, when there is total confusion in the management and finances of the two of them, that is the company signatory and the owner non-signatory. And piercing the corporate veil is a theory which permits an arbitral tribunal, when a contract has been concluded between company A and company B, to pierce the veil of company B, to decide that it has jurisdiction over Mr. C, the owner of the company B, non-signatory, when C has inappropriately and fraudulently used company B as a shield against its own liability. From my analysis of the case law from all over the world that I have performed in the second edition of my treatise on complex arbitrations, I can conclude that all these theories that I have just reviewed are to a large extent, and of course with some variations, recognized in all jurisdictions. It is not the case of the last theory, implied consent. Implied consent is a theory which is very often applied in many jurisdictions to extend, quote unquote, an arbitration clause to a non-signatory on the basis of the role that the non-signatory has played in the negotiation, performance, and or termination of the relevant agreement. Again, on the basis of my analysis of the case law, I can confirm that this theory is very, very often used in France, in Switzerland, in Belgium, in the United States, and in many, many other countries, like, for example, India or the Philippines. On the other hand, it is not accepted in other countries which strictly adhere to the principle of privity of contract, like England, Germany, Holland, Russia, and also it seems from my analysis of the Chinese case law, the People's Republic of China. It seems that in China, courts have always been reluctant when an arbitration clause has been entered into by a company of a group to extend an arbitration clause to individuals, to extend the clause to other companies of the group, as well as to extend an arbitration clause to individuals such as directors, managers, or shareholders who have been involved in the negotiation, performance, and or termination of the agreement. It appears that Chinese courts always require express evidence that the non-signatory agrees with the arbitration agreement. Well, ladies and gentlemen, this is a very quick and broad review of all the theories on the basis of which courts and tribunals tend to determine that the scope ratione personae of an arbitration clause includes a non-signatory. About all this, but unfortunately, my time is up. I thank you very much for your attention.
Professor Hanatio, thank you so much for that overview. And it really was, as you say, as we discussed before, such a massive topic with such a short amount of time to discuss so many different theories. And we're delighted that you could attend today. I did forget to mention at the beginning to the participants, we're delighted that you've been able to join. If you have any questions that you'd like us to deal with specifically, please do put them in the question and answer box, and we'll endeavor to have a look at them during the course of this session. Kieran, I'm going to turn to you now just to have your viewpoint on how some of these problems of joinder are dealt with in different parts of the world and perhaps under different institutional rules, if you could. Kieran.
Thank you, Andrew. I will say Professor Hanatio is a hard act to follow because he is in such short time and in such quick depth shown us all the various theories. And of course, each theory is going to have a different practical considerations. But I'm going to pick up on a few particular pieces. And I'm inspired by Madam Xie's introduction, which is that the Seatac rules provide very special joinder-based procedural mechanisms, which is that you can initiate a proceeding from the outset under the Seatac rules with joinder as a baseline starting point. Professor Hanatio also, in particular, focused for a moment on incorporation by reference, and I think that gives us a really nice nugget to pick up on, in particular, because large-scale infrastructure projects, large-scale construction projects can each be the source of needs for joinder in arbitral proceedings. So I'm going to focus on that in particular and think about, for your presentation, single economic transactions and how interdependent contracts may play out in the context of joinder. We've heard already a little bit about the merits of joinder. I think those can be quite clear, that where it makes sense for a single arbitration to be realistically commenced for presentation and consideration by a single arbitral tribunal. But is that fair and is that appropriate? There's certainly some merits for doing so. In particular, Madam Xie mentioned cost savings, time savings. There's the preparation of witness and other expenses that might be saved, and including that you wouldn't have contradictory outcomes. You wouldn't have multiple arbitral tribunals needing to be compensated for their time to resolve those disputes that might be interdependent. And also thinking kind of on a step-by-step process, you also wouldn't have possibly contradictory interim measures issued by various arbitral tribunals. So if you do have a single economic transaction with interdependent contracts, there's quite a few merits to having a single tribunal looking at it, so that the injunctive relief that's issued by one tribunal, for example, does not require something that's the opposite of what a different tribunal in an interdependent contract might be forbidding, for example. You wouldn't see that if you have a joined case from the outset. But it's also worth mentioning some of the arguments against joinder of disputes involving multiple contracts. One may be that while it's in the favor of a main contractor of a large-scale infrastructure construction project to have a single proceeding involving incorporation by reference and contracts that are related to one another, but for the individual contractual partners, maybe the subcontractors, for example, it may be more efficient or appropriate for them to have multiple proceedings. For example, they might want to see their confidentiality maintained. This is harder to do if you're joining multiple parties together in a single proceeding. That confidentiality may extend to contractual terms like pricing, marketing, things of that nature, but it also might be a time-based consideration. The subcontractor, for example, might be able to get a more expeditious resolution of their contract dispute if their claim or their piece of the claim is dealt with independently. So I throw those all out for consideration, because those are preliminary considerations for as to whether a case is appropriate for joinder conceptually. Now, in terms of technically and from a legal perspective, Professor Hanatio has already given us some insights into the considerations. So we can look at, well, who are the parties to the underlying contract containing the arbitration clause? If you've got multiple contracts, and incorporation by reference is the strategy or approach that's being advanced, you look at whether the parties are identical, whether the forum selection clause of the contracts differ or not. And by that, I mean whether one particular contract refers to an arbitration under particular rules, while a different contract might refer to litigation in national courts in a different jurisdiction. Generally, if there are different forum selection clauses, joinder from the outset is not going to be appropriate. And even if the tribunal doesn't have jurisdiction over a party, it can take a party's obligations under consideration. So this is where joinder of contracts and contractual disputes is not appropriate. The tribunal can be mindful of the implications of their decision-making and draw conclusions, maybe not legally binding conclusions, but conclusions with respect to the parties that are before them in that particular proceeding. So what are the solutions for that challenge? One may be to prepare a multi-party arbitration clause from the outset, sort of an umbrella arbitration clause. It can appear in a framework agreement that refers to the other individual contracts. It might be that you have identical ad hoc clauses in all of the relevant agreements. Of course, whether ad hoc arbitration is appropriate in a particular jurisdiction is a different consideration altogether. Or you could, and this might be what I would recommend, have a provision on joinder in the arbitration clauses from the outset as to whether joinder is appropriate or not. Obviously, this all involves a level of foresight for the parties from the outset. Typically in large-scale infrastructure construction projects, that may be possible, but in other settings that are smaller, parties may not anticipate that kind of proceeding. The main issue, though, from a legal perspective, as Professor Hanatia already flagged, remains consent. Even if there are compatible arbitration clauses in different contracts, that doesn't necessarily mean that the contracts are automatically deemed interrelated, and also doesn't automatically mean that the parties have consented to joinder of their contractual disputes. So if a party doesn't consent to such third-party joinder, this limits the scope of options presented to the tribunal for resolving those disputes and for their mandate as to the parties that are before them. Some will argue, though, that there is implicit consent to joinder in some cases, for example, by using certain institutional rules that permit joinder. So, for example, the Seatac rules, the ICC rules, lots of other leading rules, including SEAC and LCIA, they each have provisions on joinder. I think it's becoming increasingly common. So there is the argument to be made that simply by agreeing to arbitration under those particular rules, you might implicitly be consenting to the concept of joinder. But it raises unique challenges for the arbitral tribunal because the arbitral tribunal's duties and powers are limited to the mandate that's been presented to them. And it is truly a matter of contractual and consensual based decision-making. The tribunal cannot pass orders on parties without an agreement between the parties to have that dispute resolved before them. So especially when you get into the various theories of non-signatories that Professor Hanatio elaborated upon, whether the tribunal can properly join that non-signatory and have the power to pass orders with respect to that party is the key question. A finding by the tribunal that the party's obligations and responsibilities are indivisible with respect to the multiple contracts could elucidate that question. If a tribunal determines that cannot render a decision without all the necessary parties present or without making a decision on all those various pieces, sometimes it's referred to a forced joinder, that can be an example of where this is appropriate. Professor Hanatio also gave us a great example of what that can look like with respect to guarantee agreements. So if you have a guarantee agreement that perhaps you have party A and party B, which are parties to the commercial contract, and you also have party C, which is the parent company that has entered into a guarantee agreement with respect to one of the parties' obligations under that contract, that's a great example of where the parties' obligations and responsibilities among those two contracts and among that three tripartite set of parties can be indivisible, and it wouldn't be possible perhaps for the tribunal to enter a decision that properly reflects the issues that have been presented before them. So in those kinds of cases, it might be appropriate for a tribunal to investigate whether parallel proceedings exist and then go into the realm of consolidation, whether those parallel proceedings are in a litigation or a different arbitral setting. And I know that in this particular panel, we're not touching upon consolidation at all, but that is something to think about, whether that kind of proceeding has already been initiated with respect to a related contract. But overall, each of these considerations raises interesting questions with respect to ideas of good faith. Parties should be presented with an opportunity to adequately and completely present their cases. And so if we're in the world of a single economic transaction involving multiple contracts or multi-party contracts, the circumstances may present impediments upon the tribunal or upon the parties to properly present and hear the case and properly adjudicate on the claims that have been presented to them. So the solutions are really present in the various theories that Professor Panaccio elaborated upon for how to get appropriate third parties before the tribunal to make those decisions. The other question that's worth considering is whether joinder is mandatory in such a setting. I think virtually no institutional rules expressly answer this question. That silence some interpret as an implicit grant on the tribunal or an institution to exercise their broad discretion with respect to these ideas as to whether joinder is appropriate under the circumstances. But that broad power is subject to certain limitations, and we can look at the national procedural rules on permissive joinder in different jurisdictions to get guidance on that as to whether joinder is justifiable in certain circumstances or whether it's appropriate in those circumstances. Those factors could include specifically whether the dispute arises from the same transaction, whether there are common issues of fact and law, whether the third party to be joined is indispensable to that single economic question that's presented to them. Joinder requests should always be looked at in context. So, and this is where the institutional rules are really illuminating. You can look at the timing. So in some cases, joinder is only appropriate before the tribunal has been constituted. So in this case, the request for joinder is usually made from the moment that the case is filed. The institution will conduct its prima facie analysis of whether the parties named in the request for arbitration are proper parties to that agreement or to that contract, or whether there's any deficiency that may prevent that case from proceeding under those terms. It's a highly practical consideration. Each of the parties have a right to fully participate in the constitution and the confirmation of an arbitral tribunal. So any joinder request is subject to objection from the other side, which shifts to the tribunal to consider whether joinder is appropriate. However, there are some instances where joinder can be raised later in the case, and the ICC's 2021 rules and their revision begin to illuminate this. And in that case, Article 7.5 specifically states that a request for joinder can be made after the confirmation or appointment of the tribunal once constituted, shall be subject to the additional party accepting the constitution of the tribunal and agreeing that the terms of reference are also acceptable where applicable. So this raises novel concepts as to what timing is appropriate and whether joinder may arise, the need for joinder may arise as the case progresses. So I come back to my initial proposition about a single economic concept under multiple contracts or involving multiple parties. There might be procedural efficiencies and relevance that become clearer as a case progresses. It may be that an additional party's role only becomes evident, or its central role to a dispute only becomes evident as the case progresses, as perhaps evidence is submitted, as legal arguments are elucidated and advanced. And it might not be that very outset of a case that all these matters are clear. So I put that to the audience simply because I think that is a practical consideration that's not always obvious from the outset. If you do have a case of that nature, joinder or creates a possibility to minimize parallel proceedings in national courts or in other forums that could dilute the utility and of the award that is rendered or impede its enforcement, which brings me to my final point, which is on enforcement of these awards. Under the New York Convention, Article 5.1b, recognition and enforcement of an award may be refused in case the award that's rendered doesn't follow appropriate standards, where the arbitral procedure is not properly followed. And that could be conceptually extended to the idea of joinder. So whether joinder is proper and whether the arbitration clauses that are relied upon properly include the parties that are identified, it is a core question to be considered from the outset. We don't think about enforcement when it comes time to enforce the award. We're always thinking, and I think the arbitrators who are in this room will tell you that they're always thinking about the enforceability of their awards from the moment the arbitration comes before them. So I conclude with that comment to have you think about the beginning at the end at the beginning and the beginning at the end. And with that, I come back to you, Andrew. Thank you for your time and consideration.
Thank you so much, Kieran, and thank you for that concluding remark on enforcement, and also about bringing the end to the beginning and the beginning to the end, because in fact I'm going to beg everybody's forgiveness, and that's what I'm going to do. We've had a fascinating and brilliant question in the Q&A box, which I'd like to actually bring up now, because I'd like it to be addressed before Professor Hanachio has to run away to his arbitration. The question of enforcement obviously is really important, and we've seen in the recent decision of the Supreme Court in England, in Kebabji, a real divergence between the French approach and the English approach in relation to applicable law when deciding matters of, well, in that case, the extent of the arbitration provision. And one of our participants has asked, what's the applicable law for a tribunal to decide the joinder? Well, Professor, I mean, I think we've got the perfect person to start us off on that discussion here. Would you like to give us some comments?
Well, I suppose when he speaks of joinder, joining a non-signatory, well, that's a good question. Let me say that generally speaking, what I see is that in many cases, the analysis is based on the facts of the case. It's a factual analysis. In some cases, the parties just do not refer to an applicable law. In other cases, they refer to an applicable law, the law of the contract or the law of the seat. It really depends. But even when they refer to an applicable law, my impression is that the decision is mainly based on the facts of the case. And of course, it also depends upon the theory which is applicable. Yes, and of course, you refer to the different approach between English courts and French courts. We have seen that in many cases. What has been said on my side of the channel is that English courts look at French law with English spectacles.
It's probably a very correct allegation against the English courts, to be honest. And it's very difficult to say one is right and one is not right. They're just different, I think, is the case in point. I just wonder also, I'm going to ask Huang Shihan to have a commentary on this as well from a Chinese perspective. But before we do that, perhaps Kieran, do you have any thoughts from a US perspective, what the applicable law would be in a question of joinder before a tribunal seated in the US?
I think the question is whether joinder is a matter of procedure or substantive law. And from a US perspective, we would see that as a matter of procedure. But I think that there are some very reasonable points of view that look at it differently and see it because it has such a strong impact on the merits of the case and the outcome of a case. And they would defer to the substantive law of the contract or substantive law of the proceedings. But from a US perspective, the question you asked was specifically, what is the US perspective? We see that as a matter of procedure. So the procedural law would then apply, whether it's the law of the seat or an otherwise designated law.
Fantastic. And in mainland China, Huang Shihan, do you have any feel for how a Chinese seated arbitration would deal with the question of applicable law to the question of joinder?
Okay, I think the Chinese court may consider from three aspects. The first one is about, as mentioned by Professor Hanachio, is about the facts of the case. And the second one is where the arbitration is held and what is the procedure law. And the third one is that whether there are statutory grounds for a joinder or non-signatory parties. So I think these are the main three aspects from the Chinese court.
Thank you to all three of you for your views there. For our next sort of slot, we were going to turn to Huang Shihan in any event, who's going to give us some perspectives, firstly on the Seatac view and also on new developments in Chinese law.
Okay, thanks, Andrew. And hello to our online audience. As Professor Hanasho and Kieran has just shared a lot with respect to the global practices, I'd like to mention a few differences or conflicts between the Chinese legal practice and some of the international approaches. And also, I'll mention some new developments to be possibly made in the near future, which has been proposed in a new draft version of the Chinese arbitration law published for comments in July of 2021, so that our audience can think more comprehensively before making decisions or taking out actions. So to start with the current effective rules in China, despite of what has suggested by Professor Hanasho previously, the Chinese statute actually provides limited support for the practice of joinder and non-signatory parties. Or maybe I can even say that there are certain barriers. For example, the Chinese arbitration law rules that application for arbitration shall not be accepted by an arbitration commission where there is no arbitration agreement. And it further rules that if an arbitration agreement cannot provide clear agreement on appointing a specific arbitration institution and a clear scope of arbitration, then such an arbitration agreement is invalid. So we can imagine it can be difficult for a non-signatory party to meet all of these conditions. So in this sense, if you are considering an enforcement in China, especially where the applicable law is the Chinese law, then you have to think about these rules before drafting the arbitration agreement or making decisions. But despite of what I have just said, in the Chinese practices, a non-signatory party quite often becomes a party to an arbitration where there is an agency relationship involved, provided that only either the principal or the agent can become a party to such an arbitration. However, this is very limited compared to the theories for binding non-signatory parties in other jurisdictions, such as incorporation by reference, assumption, agency, veil piercing, alter ego, or estoppel, as just shared by Professor Hanasho and Kieran. So, but some practitioners think there are also the group theory and the estoppel theory in Chinese practice, because in 2018, in the case between Yilan and the Amani Group, the Shandong Higher People's Court ruled that Mr. Amani Hong Kong, and the Amani Shanghai shall all be bound to the agreement concluded between Yilan and the Amani headquarters, for two reasons. One is that all of them had joined the arbitration in Hong Kong, and the Yilan had made counterclaims. And the second reason is that all parties from Amani Group was involved in the performing of the agreement. However, this court ruling was revoked by the Supreme People's Court due to the withdrawal of the case by Yilan, which made the situation in China unclear again. So it seems that there is a gap between the Chinese and the international practice. To make up the gap, a number of arbitration institutions located in China for international arbitrations provide a path in their arbitration rules to leave space for the series of other jurisdictions. To take Seatac Arbitration Rules 2015 as an example, it provides that where the law applicable to an arbitration agreement has different provisions as to the form and validity of the arbitration agreement, those provisions shall prevail. This means if the applicable law to an arbitration agreement is a foreign law, then the theories of binding non-signatory parties in that jurisdiction will be recognized. So as mentioned at the start of my speaking, The new draft version of the Chinese arbitration law also proposed new rules to bind non-signatory parties. It provides that where there is a principal contract and a subordinate contract involved in a dispute, the arbitration agreement for the principal contract shall prevail, no matter whether there is a different arbitration agreement in the subordinate contract. It also provides that where the law allows a shareholder of a company or a limited partner of a partnership to claim on behalf of the entity, then such shareholder or limited partner will be bound to the arbitration agreement between the entity and its counterpart. So as the arbitration law is of the highest authority for the Chinese arbitration practice, these two statutory rules will become compulsory rules to bind non-signatory parties if the new draft version will come into force in the near future. But however, this all may also cause potential problems or conflicts with practices in other jurisdictions. For example, if in a transaction there are three companies, company A, B, and C, company A is a Chinese company, while company B and C are the US companies. Company A concludes a principal contract with company B, and they agree that the dispute shall be submitted to arbitration in China, while company B and C concludes a related guarantee contract where it is agreed that dispute shall be submitted to arbitration in the US. So if disputes arise among the three parties, then company C will be bound to the arbitration agreement between A and C, and hence be bound to the arbitration in China, despite that there is a different arbitration agreement in the guarantee contract. So in such circumstances, enforcement against company C in the US may face problems because the US court may disagree, as we have read that the Sixth Circuit once ruled where a company is not a party to a contract, then it is not directly subject to the contract's arbitration clause. And also the Fifth Circuit once ruled that arbitration is a matter of contract, and despite the strong policy in its favor, a party cannot be compelled to arbitrate in a dispute that he has not agreed to submit. Also, the Second Circuit once ruled that an American non-signatory cannot be bound to arbitrate in the absence of a full showing of facts supporting an articulable theory based on American contract law or American agency law. To hold otherwise would defeat the ordinary and customary expectation of experienced business persons. So actually, the issue of non-signatory parties in international arbitrations is very complex for Chinese companies, and sometimes it is even confused with other issues. We have handled a case before which we entered into at the enforcement stage. In this case, three companies of the same German group initiated an arbitration against a Chinese company. The two German companies of the group supplies to the respondent, which is the Chinese party, at stage 1, and it is agreed in the contract that arbitration shall be submitted to a well-known arbitration institution, and the applicable law is the laws of England and Wales. Later, at stage 2, the group decides to set up a Chinese subsidiary to supply the respondent. And in stage 2 contract, it is agreed that arbitration shall be submitted to the same well-known arbitration institution, and the applicable law is the Chinese law. And it further states that in stage 2 contract is a complete contract which shall replace all previous agreements and consent. In this case, actually, all disputes were between the Chinese subsidiary of the German group and the respondent, which means all disputes were in stage 2. But in order to initiate arbitration under the names of the three applicants of the German group, on one hand, the applicants of the German group claimed that there were arbitration agreements between them and the respondent, respectively, in stage 1 and stage 2. And on the other hand, they claimed that they were of the same group, and the stage 2 transaction was a continuation in the arbitration as applicants, despite of the challenge of the respondent. the tribunal decided to keep the two German companies in the arbitration. But this is questionable. So if the tribunal regards this as a consolidation of arbitrations on the arbitration agreements of stage 1 and stage 2, the question is that since all the disputes are in stage 2, shouldn't stage A agreement be irrelevant? But if the tribunal regards this as binding to non-signatory parties to the arbitration agreement of stage 2, then the question is, considering stage 2 contract is a very comprehensive contract, and it also rules that it replaces all previous agreements and consent. Then shall the group theory be allowed in such a circumstance? I have to say in this case, the respondent only raised the general challenges by saying it was not appropriate for the two German companies to join the arbitration, but without any issues. So I think also our topic today is an angle of the international arbitration practice, but they need to be dealt with very carefully. And it's worth noting for our Chinese audiences that they may be bound to international arbitrations, though they have not signed any arbitration agreement. Okay, this is all I'd like to share today. Thank you. And I'll give it back to you.
Yeah, thank you so much, Hong Shihan. And it's really, it is a really interesting point to end on, that parties need to be aware that they may be bound to arbitrations without having signed an arbitration agreement. And I think particularly for mainland Chinese companies, there's this idea that if we haven't signed the document, then we can't be bound. So it's a good reminder that not all law systems work the same way. And that's why I'm so delighted to have Linda Yang wrapping up this session for us, because she is going to give us some strategies for solutions, some drafting solutions, so that at the beginning of the relationship between the parties, we work out whether joinder can be part of what we see as the backdrop for our arbitrations. Linda.
Well, thank you very much, Andrew. Our firm is very honored to support and participate the first webinar this year of International Arbitration Insight series, co-organized by Seatac, Walter Clouvers, and IDRA. Well, I'd like to share my observations and opinions as a lawyer on joinder under multi-party and multi-contract situation. Well, as legal professionals, we all know that dispute resolution clause is one of the midnight clauses, which is normally not discussed among the parties with priority. So when talking about dispute resolution, parties normally have more concerns on some basic points, like selection of arbitration institution, the place of arbitration, the governing law, the language of arbitration, etc., and also cost structure of the arbitration institutions. Normally, it's also a key concern of the parties. Well, I would say that these are important factors in the bilateral agreement. However, there are many projects and transactions with multi-party and multi-contract situations, which Professor Hanok and also Kieran Shin already explained. Well, for example, in an international construction project, it usually involves several parties with interrelated contracts and subcontracts. Well, there are also the same situations under an M&A transaction. The purchaser acquires a target from multi-sellers with SPA, additional extending to third parties like a guarantor, or acquire simultaneously more than one target from the same seller through separate SPAs. So even a single SPA has clauses on guarantees, representations, and warranties given by the seller. So in the event of dispute between the target company and third parties relating to subject covered by the guarantees, representations, and warranties in the SPA, the purchaser will face a situation in which it needs to pursue claims for indemnifications against the seller under the SPA. The purchaser is therefore faced with parallel proceedings involving different parties and often with different dispute resolution mechanisms. So, under multi-party and multi-contract situation, the party need to look deeper on how to work out the arbitration arrangements which are best to solve the disputes efficiently with reasonable cost. Well, first of all, I think as a lawyer, you should help your client to make a thorough analysis and evaluate if it's in the favor of the client for aligned multi-party arbitration arrangement. As I just mentioned, a construction project normally involves several parties with interrelated contracts, and any dispute between the employer and the general contractor may arise from the same facts and giving rise to similar legal issues in a dispute between the general contractor and the subcontractor. For example, the claims on extension of time and extra cost. In a construction project, an aligned multi-party arbitration arrangement are usually in the interest of general contractor, who otherwise will need to bring separate claims against the subcontractor before a different tribunal to recover damages that may have been awarded in favor of the employer in a previous arbitration. Under this circumstance, the main interest of employer is only to hold the general contractor fully liable, and it doesn't care whether the contractor will be able to pass this liability to any other party. So obviously, if your client is an employer, there's no concern on joinder proceeding. Well, the same thing in an M&A transaction. The purchaser has a particular interest for joinder, but not the seller. So after the analysis, if it's in favor of the client to have an aligned arbitration arrangement, you should look into the arbitration rules of different arbitration institutions carefully. There was studies conducted by School of International Arbitration at Queen Mary University of London. Potential users of arbitration perceived that lack of third-party mechanism was one of the worst characteristics of international arbitration. Well, since the study was first published in 2006, many leading arbitration institutions have revised their arbitration rules to facilitate multi-party dispute, the joinder of third parties, and consolidation of cases. Rules allowing joinder are intended to permit proceedings to occur more efficiently and to preclude the possibility of conflicting results. Well, Seatac, as one of the leading international arbitration institutions, it has detailed provisions on joinder in its rules in Article 18. Under Seatac rules, a party wishing to join an additional party to the arbitration may file the request of joinder with Seatac based on the arbitration agreement that prima facie binds the additional party. If the request of joinder is filed after the formation of the tribunal, a decision shall be made by Seatac after the tribunal hears from all parties, including the additional party, if the tribunal considers the joinder necessary. Well, if there's any party objects the arbitration agreement or jurisdiction over the arbitration with respect to the joinder proceedings, Seatac has the power to decide on its jurisdiction based on arbitration agreement and relevant evidence. Well, ICC rules of 2021 also allow joinder on additional party, such as a subcontractor. But there must be an aligned arbitration clause binding all parties to solve dispute by ICC arbitration. The request is made to Secretariat before the formation of the tribunal, and the request must indicate the legal basis for the joinder. If the joinder is allowed, claims may be made by any party against any other party. The tribunal may follow the joinder of an additional party even if the request is made after formation of the tribunal, provided that additional party accepts the constitution of the tribunal and agrees to the term of reference. Well, the London Court of International Arbitration Rules of 2020 empowers the tribunal to allow one or more third party to be joined in the arbitration, provided that the third party and applicant party have consented expressly to the joinder. As such, the LCIA rules allow the forced joinder of a party as long as the applicant party and the party to be joined agree to the joinder. The consent of other party involved in arbitration is not required. So from my explanation on the rules of 3 different leading arbitration institutions, you can see some differences among the rules of different arbitration institutions. So you should select the best one which can fit the requirement of your client. Well, after you select the arbitration institution, you need to work out the arbitration agreements as a aligned mechanism. There are a few key points to be concerned. First, to select the same arbitration institution for dispute resolution. And second, you should give consent for multi-party arbitration and detailed provisions for joinder before the dispute arises in arbitration clauses in the main contract. For example, in the international construction project, you should give such clauses in the main construction contract as well as the subcontract. And also try to reach a single arbitration clause if all relevant parties wishes to resolve their disputes in a single set of multi-party arbitration proceedings. Well, if you couldn't reach agreement, at least to enter, that if you couldn't reach one set of arbitration agreement, at least you should reach 2 or more identical arbitration clauses that expressly provide for multi-party proceedings. But you must be very, very carefully that any unclear drafting may lead to confusion and disagreement. Shane also mentioned that you should also consider the civil law of the country where you are going to bring the arbitral word to be recognized and enforced. So you must have a very thorough considerations when you draft an arbitration agreement, especially under the international construction projects and M&A transactions. Well, thank you for your attention.
Thank you so much, Linda. And I'm really delighted that you made that point that parties really do need to pay attention to the different potential rules and the different potential institutions. We've had a question in the question box whether it's possible to require joinder for related cases under different arbitration rules, but within the same arbitration institute. My instinct is it's going to be exceedingly difficult if you don't have a similar platform in the different arbitration agreements. If you've got 2 arbitration agreements, maybe around a similar economic interest, but those arbitration agreements are different. As a drafter, what would you say to that?
Well, as a drafter, actually, as mentioned, you need to have a very thorough analysis on the situation of your client. And also you need to look into the rules of different arbitration institutions. You must make sure that your arbitration agreement is in line with these rules. And also you should consider the factor of being recognized and enforced in other countries. So make it an aligned mechanism. It could be very complicated and lots of points to be concerned.
Yeah, absolutely. I think that's absolutely the case. I mean, often as practitioners, though, we end up picking up the pieces, as it were, from what has happened when people haven't necessarily taken that overview as you've described at the beginning of the relationship to ensure that the dispute resolution mechanisms are in fact aligned.
Right.
On the other hand, I've also seen situations where parties have deliberately chosen to have different dispute resolution clauses, because they want to be in a situation where in one dispute they can take one position, and in a different dispute they can take a different position. Is that something that you've seen as well?
Yes, that's why I mentioned that the first point as a lawyer you need to consider is the position of your client in the chain of the transactions or the project. For example, if you are a general contractor, it's in your interest to have a joinder. If you're just an employer or you are a subcontractor, it's not really necessary.
Yeah, okay. Well, brilliant. Thank you so much to our 4 speakers today. I think it's been a really, it's obviously a very difficult subject, and it's one that actually develops on a case-by-case basis. So it's actually really difficult to give you the audience a one answer fits all. And the parties are here to be able to help you think about either the situation that comes your way, dealing with existing arbitration clauses, or as Linda says, right at the beginning of the relationship, trying to get a solution at the beginning without jeopardizing your enforcement at the end of the day. We do have a couple of minutes for questions, but I'm quite aware that we have another session following quickly on, and maybe we can move, if there are no more questions coming up in the question box, we can move directly on to dealing with consolidation. Okay, on that point, I think it's probably best if we move straight into the next session.
Thank you, speakers of session 1. That was really interesting discussion. Joinder issue is always a very complicated procedure issue in arbitrations. Not only, because of the parties' autonomy, whether they agree to do so, and whether there is any arbitral clause prima facie binds on the parties, but also there are some practical considerations, from the institution's perspective, whether the joinder's exercise of its procedural rights will influence the ongoing or already gone through proceedings in a positive or negative way is also, behind the consideration of the tribunal or the institution. Now let's come to the samely complicated issue, procedure issue, that's consolidation and large-scale arbitration. The moderator is Dr. Fan Yang. Dr. Fan Yang has helped us a lot in coordinating this event. So our thanks first goes to Dr. Fan Yang. Fan is a partner of Stephenson Harwood LLP London and advises on the laws of England and Wales, having been one of the first mainland Chinese called to the bar of England and Wales. She specializes in international arbitration and cross-border dispute resolution. She's a fellow of the Chartered Institute of Arbitrators and a former vice chairperson of the CIR East Asia branch. She's the founding director of International Dispute Resolution Academy, one of the co-organizers. And in addition to representing clients as counsel in international arbitration and cross-border mediation, she has also acted as mediator and arbitrators by being listed on the panel of many internationally renowned arbitration institutions. And also she is an accredited mediator. So Fan, now the floor is yours.
Thank you so very much, Ms. Lu Fei. I thank you for your most kind introduction. I'm most grateful to Seatac and to Ms. Lu Fei in particular for your vision and for your efforts and your commitment that have been tremendous for putting together these series of international arbitration insights. As I understand, it's the first series of bilingual Seatac live webinars. I hope that our audience will enjoy all the discussions that we have here today. So for that, I thank you again, Ms. Lu Fei. We have heard a very interesting discussion from our first panel on joinder and related issues, including, of course, non-signatory parties. And now we're going to look into consolidation and larger scale arbitration. And perhaps some of the participants are already wondering, so what exactly are the differences between these two? And are they both procedural matters, as one of our speakers, Kieran, and discussed earlier in the first panel? And we're going to hear from our first speaker, Mr. Simon Greenberg. Please allow me to quickly introduce Simon. Simon is in Clifford Chance International Arbitration Group. Simon acts as both counsel and arbitrator and has extensive experience of both ad hoc and arbitrations under the rules of most major international arbitral institutions, notably the ICC, for example. And his experience covers numerous governing laws and seats of arbitration and encompasses a range of dispute types and business sectors such as telecoms, technology, IP, aviation, construction and infrastructure, energy and resources, shareholders, post-acquisition, and general commercial disputes. Before joining Clifford Chance in early 2012, Simon spent 4 years as Deputy Secretary General of the ICC International Court of Arbitration in Paris. Having previously practiced with the leading international dispute resolution team in Paris and also teams in Australia, he remains close to the ICC as a court member in Australia and of the ICC International Court of Arbitration. Simon is a lecturer at the Institute of Political Science of Paris since 2008 and a visiting professor of international commercial arbitration at Hong Kong University since 2011. And a regular speaker at arbitration conferences. He has published more than 30 journal articles and 2 books on subjects of international arbitration. And without further ado, please join me and welcome Simon, and over to you.
Thank you very much, Fan, for the kind introduction, and good evening to everybody. Good morning if there are any others out there like me who are in the northern part of the world. I'm going to talk about consolidation, and in order to do so, I'm going to try to get my slides up on the screen, and Fan's going to tell me if I've succeeded in doing that. Can you see, Fan, my presentation now?
Yes, thumbs up.
Great.
Good
Great.
job.
Okay. So those of you who have heard me speak know that I don't read what's on the slides, and I may not even say exactly what's on the slides, but they are there to help me along and to help you along in understanding broadly where I'm going. The first point is to recall, as one of the speakers this morning already, or this afternoon already mentioned, there is a very large number of international arbitrations now that involve more than one party, more than 2 parties rather. The figure I have up on the screen there is around 40%, and that is based on ICC statistics, but that's still a fairly good reflection of global statistics in terms of the proportion of arbitrations that involve more than 2 parties. And of course, some arbitrations, and Stacy will talk more about those, involve many, many, many parties. Now, whenever there is an arbitration with more than 2 parties, there are special issues of consent and procedural mechanisms that may need to be dealt with. They may need to be dealt with, but they also may not need to be dealt with, depending whether parties have managed to agree on a way forward. The other element that can make arbitrations complex in this context is where there is more than one arbitration agreement involved in a dispute. And I don't have any statistics for that, but there is also a growing number of cases where there is more than one arbitration agreement. And so these two concepts, multiple party arbitrations and multiple arbitration agreement arbitrations, give rise to different challenges and different procedural mechanisms to deal with those challenges. Now, there are three related procedural mechanisms that I've listed here at the bottom of my slides. Now, joinder of additional parties was, of course, part of the subject dealt with by our previous panel. Multiple contract or multiple arbitration agreement proceedings, and consolidation in the narrow sense. And all three of those concepts, depending on your background and depending on your understanding, all three of those concepts could potentially fall under the umbrella of the question of consolidation. So I'm going to very briefly define each of them and then get to consolidation as such as the last point, in order that we have a clear understanding of what we're talking about and in order to separate these three very closely related concepts. The one thing that all three concepts have in common is the notion of consent. Arbitration, as we know, is a consensual process, particularly in the international field where there cannot be any kind of mandatory or ordered arbitration. Only parties who have consented to be a party to an arbitration can be bound by an arbitration. And that notion of consent goes beyond the mere consent to arbitrate in the first place. It goes to the notion of consent about to whom or with whom you agree to arbitrate and in what circumstances you agree to arbitrate. And so that's why when we get to joinder and consolidation and multi-arbitration agreement, it's not just a question of whether somebody agreed to arbitrate, and that was dealt with by the first panel, but it's a question of whether all of the parties agreed to arbitrate in those particular circumstances. Circumstances being a consolidated arbitration, or an arbitration involving multiple contracts, or an arbitration where somebody can be joined to that arbitration at some later stage. And when we talk about consent, there are three ways to look at it. Actual consent, in terms of some clear document or other clear evidence that a party gave express consent. And that might be by signing up to a set of arbitration rules that contains, for example, a consolidation provision or a joinder provision. Second, constructive consent. And that's sort of what Professor Hanotio earlier described as implied consent, where there is something about the facts and circumstances of the parties or their relationship from which we can presume consent to the type of arbitration concerned. And there is another element which relates to the constitution of the arbitral tribunal, because even if we have consented, for example, to a set of rules that allows for the consolidation of two arbitrations, that might not be possible if the arbitral tribunal has already been appointed in one of them, because any new parties involved in the second case to be consolidated may not have given their consent to the appointment of that arbitral tribunal, or may not have been given the opportunity to participate in the appointment of that arbitral tribunal. So those three elements of consent are critical when we're considering these kinds of more complex arbitrations, and they really apply across all three of those mechanisms. So what is joinder? And I appreciate this is something discussed in the context of non-signatories by the previous panel, but let's just look at what the mechanism is so that we are clear. The joinder is where we have one arbitration between two parties, or it could be more parties, and one of those parties wants to join an additional party to the procedure. And that additional party could be somebody who is a signatory to the arbitration agreement, but it could also be a non-signatory to the arbitration agreement, in which case you have all of those issues that Professor Hanotio described as part of the question about whether the party can be joined or not. So that's joinder. Joinder was traditionally not possible in international arbitration. It's only sort of in the early 2000s, around that period, that joinder started to be allowed through processes and through revisions to arbitration rules. So the second concept I want to talk about, because this one is very closely related to what I call consolidation. The second concept is multi-contract arbitration proceedings. And this is a situation where there are claims in a single arbitration that are brought on the basis of more than one contract. And they may or may not involve more than one arbitration agreement. It's possible that not all of the contracts contain arbitration agreements. And what I've tried to do on this next slide is to illustrate this idea of a single arbitration raising claims under multiple different contracts. And you can see that there are different ways that this could happen. It might be that the claimant has brought claims under more than one contract and more than one arbitration agreement. Or it might be that the claimant has brought claims under one contract or one arbitration agreement, and the respondent has made counterclaims under another. And in both of those scenarios, it's very closely related to a consolidation situation, because those two sets of claims under the different contracts, or 3 or 4 or 5 different contracts, might have been brought as separate arbitration processes that need to be consolidated. And so most sets of arbitration rules these days deal with those concepts separately. The concept of a single claim or a single arbitration raising claims under different arbitration agreements on the one hand, and a separate concept of consolidating two or more separate arbitration proceedings that have been commenced separately. So the concepts are distinct, but they raise almost the same issues. And those same issues come down to those fundamental considerations of consent. Number one, did all of the parties consent to arbitrate at all? Number two, did they consent to this particular procedure or seat of arbitration or arbitral institution? Those are independent of consolidation and multi-contract claims. But number three, did all of the parties consent expressly or implicitly to a single procedure bringing claims under separate sets of contracts? And that's where it gets the most complex for some people, but in my view also the most interesting for us arbitration geeks. So of course, within any commercial scenario where there is a potential to raise claims under multiple contracts, it might be that all of the parties to the different contracts are the same, which makes the process a bit simpler. But it might be that there are different parties to some of the contracts. It might be that the contracts are sort of chain contracts. So between an owner and a head contractor and a head contractor and a subcontractor. For example, it's a chain. Or it might be that they are contracts that sit side by side, where one entity has been contracted to do two different things at the same time. And one very important element to consider, both whether it's a question of consolidation or a question of multi-contract arbitration, is whether the underlying arbitration clauses are compatible with each other. Because, for example, if in one contract, the seat of the arbitration is designated as Hong Kong, and in the other contract, the seat of the arbitration is designated as Singapore, in principle, it's impossible to have a consolidated arbitration unless all of the parties agree to rectify that inconsistency, and they agree on either Hong Kong or Singapore. So whenever there are multi-contract scenarios, whether it's because that's the way the arbitration has been commenced, or it's because there's a question of consolidating two separate claims, all of those questions of consent and compatibility of arbitration agreements will come up.
Sorry, my apologies, Simon. Just before you move on to this slide, if you go back to the last slide, I just want to quickly point out that there may be an oversight in the Chinese translation of this slide. So just to clarify, when we say here, dealt with by previous panel, you are referring to the last panel of today's webinar.
Yes.
And the translation referred to the previous arbitral tribunal. So I just want to clarify that 不是之前的仲裁庭处理啊，它这个中文上应该是指我们今天的这场会议的第一场的这些演讲嘉宾已经处理的问题。Okay, sorry. Yes, please continue. Thank you.
Thanks very much, Fan, for clarifying. I'm afraid my Chinese is not good enough to check any of these translations. So I was talking about consent. I was talking about consent in particular in the context of multi-arbitration agreement proceedings. And I said that in order to get a multi-arbitration agreement proceeding to work, you need to have compatible arbitration agreements. I gave the example of Singapore and Hong Kong as conflicting seats. We could also think of one arbitration agreement providing for Chinese as the language of arbitration and the other providing for English as the language. Again, I don't see how such a case could be consolidated unless the parties agreed on one of those two languages or some other language. We could also think of an example where one arbitration clause provides for the appointment of a sole arbitrator and the other provides for the appointment of three. Those are, for me, inherent incompatibilities. And unless the parties have agreed on a way forward, there is in principle no way to consolidate those claims. But even once we get over that step of the compatibility of the arbitration agreements, a second issue is whether the parties have consented to a multi-contract, multi-arbitration agreement proceeding. And it's relatively rare. It's not impossible. It can happen that there is express consent, but it's pretty rare to find express consent clauses in even related contracts. And so most often, when we're considering the consolidation of claims arising from different arbitration agreements, we're looking for constructive or implied consent. I'm not talking about consent to arbitrate. That was what Professor Hanotio was talking about. I'm talking about consent to a consolidated arbitration or consent to an arbitration which involves claims arising from those different contracts. And there is a whole variety of rules and processes and principles that have sort of evolved in arbitration practice to try to determine whether there is implicit consent to such a single proceeding bringing claims under different arbitration agreements. So now, having sort of talked about the neighboring concepts of joinder, but in particular of multi-contract arbitration proceedings, let's now talk about the narrow concept of consolidation. And consolidation is really a very simple process. It is, at least in my definition of consolidation, it is where you have two cases and they have been commenced at separate times, haven't been commenced both at once, and there is a question as to whether they should be consolidated into a single case. And of course, it's possible that this question of consolidation does not involve more than one contract. It's possible in my little diagram here that case number 1 and case number 2 have been brought under the same contract and the same arbitration agreement. And if that's true, it's much simpler to consolidate them because you don't have those issues of multiple contracts that I just talked about. But you will still have issues concerning the manner in which and the timing in which the arbitral tribunal was appointed. And if the arbitral tribunal has already been appointed in one of the cases, even if the parties are identical, there may still be valid objections to the process of consolidation. And so arbitral rules that have set out provisions expressly dealing with consolidation, which is most arbitral rules these days. The ICC, where I was spent many years of my career and I was closely involved in developing its rules, has been a pioneer in the area of both consolidation, joinder, and multi-contract arbitrations. But as of 2022, most arbitral rules deal with this. And when they do, they deal with this question of the timing of the appointment of the arbitral tribunal, because a cardinal principle in international arbitration is that every party should have the right to participate in the constitution of the arbitral tribunal. So, as I say, these two cases to be consolidated might arise from the same contract, in which case it's more straightforward, but it's not. It still has issues of consent that need to be dealt with. And this question of consolidation might alternatively arise in a multi-contract or multi-arbitration agreement scenario, and that's when it becomes more complex for the reasons that I spoke about earlier. So, in terms of concluding remarks, these three neighboring mechanisms, which all relate to the broad sense of the word consolidation, are, even though there are many cases where they could potentially come up, in the vast majority, the parties agree on a way forward, in my experience. Parties agree to consolidate or agree to joinder or agree that actually it doesn't make sense in the particular circumstances. But there is a small proportion of cases where the parties don't agree. And that's where the provisions that have developed over the last roughly 20 years in international arbitration rules are very helpful, because they facilitate possible consolidations in certain circumstances and provide a framework and basic elements to see whether it can take place. I will finish by repeating a comment that one of the previous panel speakers made, and I don't remember who, which is that if you're drafting contracts where there is a potential to have additional parties or additional related contracts that may want to be involved in disputes, then the best way to deal with that is by some upfront drafting. And that upfront drafting might be to say that we don't want any consolidation, we don't want any joinder, we don't want any multi-party disputes. Or it might be to say, we do want to facilitate consolidation, we do want to facilitate multi-arbitration agreement disputes, and we do want to facilitate joinder, and this is how we want to do it. Thank you.
Thank you very much indeed, Simon. Very insightful discussion on consolidation and also clarify the different types of potential, proceedings that we are referring to here. And I think your last comment is particularly interesting, and especially when we look at the potential impacts on the perceived outcome from the parties' perspectives. I wonder whether it's always true that if the consolidation is at the advantage of one party, then it will inevitably to the detriment of some other parties involved. And we can come back to invite you to share with us and to answer some questions later at the Q&A session. Now, please allow me to move on to introduce our second speaker of today's this second panel. And the good news, by the way, is that all the speakers of this panel have most kindly prepared PPTs. So it will be much easier to facilitate the simultaneous interpretation and also for the benefits of the participants whose first language is not English. And so our next speaker, Professor Stacy Strong. Dr. S.I. Strong specialized in international dispute resolution and comparative law, with a particular emphasis on international commercial arbitration and large-scale class and collective suits. Prior to joining the University of Sydney, Dr. Strong taught at the University of Cambridge and Oxford in the United Kingdom, as well as Georgetown Law Center and the University of Missouri in the United States. Dr. Strong is an experienced practitioner, having acted as counsel at Bacon & McKenzie after working as a dual qualified lawyer, US Attorney and England Solicitor in the New York and London offices of Weil, Goshaw and Manges. Dr. Strong has published over 130 award-winning books, chapters, and articles in Europe, Asia, and the Americas, including a long list. I will please allow me to skip that. And I can see that there is also a reference to a Spanish, a Spanish book or a book in Spanish. And of course, many of Professor Strong's books have been translated into including Chinese and also Spanish, French, Russian, very impressive. And Dr. Strong, who holds a PhD in law from the University of Cambridge and a DPhil from the University of Oxford and a JD from Duke University, an MPW from the University of Southern California, and a BA from the University of California, Davis, sits as an arbitrator on a variety of international commercial and trust-related matters. And without further ado, please join me and welcome our second speaker of the second panel, Professor Strong. The floor is yours.
Thank you so much, Dr. Yang, and thank you also to Ms. Lufei for the invitation to speak at this illustrious event. I'm so sorry that I cannot be there in person. Obviously, the entire event is remote, but I am very honored to be amongst the participants. I will go ahead and share my screen, and like Simon, I will hope that it all comes off successfully. It looks like it's successful from my end, and I have a note that says the participants can see my application. I will apologize in advance. I do speak very quickly. This is in fact me slowing down, but I doubtless will speed up again. I hope that Dr. Yang will make some indication, waving her hand or interrupting me if I do go too quickly for the interpreters or for or for the others. I do apologize. My life goes at a very fast speed, I think. All right, so let me begin by acknowledging the Gadigal people of the Eora Nation on whose land the University of Sydney stands, and the Gweagal people of the Darawal Nation on whose land I live. I would also like to pay respect to any Aboriginal or Torres Strait Islanders who are with us today, and to elders past, present, and emerging. Sovereignty was never ceded. It always was and always will be First Nations land. So I'm going to speak to you today about the 3 different types of large-scale arbitration. If you're interested in this subject, I did write a book about it, which was published by Oxford University Press, and it goes into exhaustive detail about the different types and a number of the different issues that we are talking about in the panels today, particularly with respect to consent. We start, though, by defining the 3 different types. First and most well-known is called class arbitration. The term comes from the United States from the judicial mechanism known as class actions, which many of you may know about in the judicial setting. If I look like I'm starting to be in pain, it's because my very small dog has decided to wake up just now when I start speaking, and she's going to at some point try to jump into my arms. So hopefully she will stay down and not bark. So class arbitration began in the United States in the 1980s. It was not initially a legislative effort. It was a common law effort. So an effort by the courts who were faced with, on the one hand, parties who had an arbitration agreement, and on the other hand, situations that involved what would normally be a class action suit, meaning many, many people with identical claims. Some courts said we must send it to court in order to give effect to the public policies in favor of class actions. And some courts said, no, we must give effect to the arbitration agreements, which at that time were considered to only allow bilateral, meaning 2-party arbitration. In the 1980s, some California judges, I'm from California, decided, let us converge these 2 methods and allow a large-scale class proceeding in arbitration. That will give effect to both public policy concerns, the concern about wanting to allow people to go forward in a group, and a policy that favors enforcement of arbitration agreements. Several decades later, in 2003, the United States Supreme Court, in a case called Green Tree Financial Corporation versus Basel, decided implicitly that class arbitration was an acceptable process. The case had to do with the appointment of arbitrators and whether arbitrators, not appointment of arbitrators, but whether arbitrators could decide that class proceedings were proper. And a plurality, meaning a majority of justices, but deciding on different rationales, agreed that it was all right, that it was proper. So immediately afterwards, the American Arbitration Association, known as the AAA, and JAMS created formal rule sets that were to supplement the standard rules of arbitration that existed. So basically, once a JAMS or AAA arbitration was considered a potential class arbitration, these rules would apply not to require class actions or class arbitration, but to give the process of determining whether class proceedings were proper a particular process to follow. And then subsequently, if class proceedings were required by the arbitrator, then how that process would occur. So the mere existence of the rules did not automatically lead to class arbitrations. The mechanism under the AAA and JAMS rules is almost identical to the class action mechanism in court, known as Rule 23 of the Federal Rules of Civil Procedure. So the key element of US class actions is representative claims, meaning that there is one person who acts on behalf of all the other people, and the other people do not have a chance to dictate the strategy. Only that lead representative does. And the other element is that these are opt-out proceedings, meaning that the court or the arbitrator decides the basic boundaries of the class. For example, everybody who used a Visa credit card in the United States, in the state of Missouri, from 2003 to 2004. So it's defined by factual elements, and then you eventually find out the names of the individuals. Those individuals are in the class unless and until they opt out, meaning that they provide notice that they do not want to be part of the class. This is very controversial outside the United States, the concept of representative plaintiffs and the concept of opt-out proceedings. Class arbitration was very, very successful. There were approximately 300 AAA procedures that we know about alone between 2003 and 2010. In 2010, the United States Supreme Court decided that it was very worried about class arbitration. The United States Supreme Court was also very worried about class actions. They just did not like the class mechanism anywhere. So there was a series of decisions, 3 decisions dealing with the concept of consent that Simon and Bernard spoke about earlier, meaning whether there could be any implied consent to the procedure of our class arbitration. I should be very clear here that the parties all consented to arbitration, so that initial consent was there. It's just whether they agreed to this particular process of joining together. I won't go into those cases because I suspect I will run out of time very soon, and I have 8 slides, and this is only the first. Class arbitration has been seen successfully in Colombia, in Latin America, and has been considered by both the Canadian Supreme Court as well as one of the Canadian provinces, Manitoba. Canada has not yet permitted class arbitration judicially or legislatively, but in Colombia, we know of at least one proceeding. It's Valencia and Bancolombia. There is a second type, in fact, there's 2 more types, but there's a second type of large-scale arbitration called collective arbitration. There are a lot of different ways that this can proceed, but the key element here is that parties must opt into the proceedings. So the parties must affirmatively tell the arbitrators that they want to be joined. This tends to lead to smaller classes, and it can be difficult to identify all these people in advance. The procedures are available by statute in Spain, by the arbitral rule set promulgated by the DIS, which is the German Arbitral Institution, and it's called the Supplementary Rules on Corporate Law Disputes. And then in the United States, we use the typical class mechanism that you see in class arbitration, but parties opt in instead of opt out. So lots of different options, but there is no concern about whether the plaintiffs or the claimants have consented to this type of procedure. The last procedure is called mass arbitration, and it is only seen in the investment realm. The Arbitrat and Argentine Republic case discuss this, and the Arbitrat decision was approved of by several subsequent arbitration tribunals. But essentially, the Arbitrat tribunal said that there were elements of class proceedings as well as collective proceedings, meaning that all the parties opted in affirmatively, which is like collective arbitration. But once they were in, then the lead claimant in the Arbitrat case ran all of the strategy. And that was more like class arbitration. So I won't talk too much about that because that's kind of its own particular type of proceeding. You need to have several factual elements in place before large-scale arbitration can occur, because I suspect a lot of people on this call are thinking, well, is it ever going to happen here? will it happen to me? First, large-scale arbitration develops when there is a social or legal need for it, that basically you are going to have large numbers of disputes, usually involving consumers that have the identical or almost identical types of claims and types of damages. So remember, my example was that we had a credit card plaintiffs who used a Visa credit card in Missouri between 2003, 2004. The damage might be that the provider added an extra charge, 40 cents worth every time the card was used. Everybody has the exact same type of claim, even though they may have used the card more or less. So their actual damages may differ depending on how often they use the card. But legally and factually, there's not much difference, which makes it very appropriate for group use. If there are some differences, maybe some people were charged 40 cents, some people were charged 20 cents per transaction, you can create subgroups to handle those issues separately. Typically, all kinds of large-scale arbitration involve small value claims that would otherwise be useless to proceed on a bilateral basis. If you have a $20 claim in arbitration or in litigation, you're not going to dispute that. The cost of your attorney or the cost of filing is going to be far in excess. But if we think about this from a regulatory perspective, we need to address that wrongdoing or the wrongdoer will continue to act badly. So a class or collective lawsuit may be the only way to address this particular type of wrongdoing. That's not to say that you cannot have large value claims. In Avoclat, which was the investment proceeding, I think the standard claim was about $40,000 to $60,000, which is very small for an investment dispute, but it is a lot of money, at least for me. So this concept of a small claim may depend on the context. You also need some legal elements to exist, and these will sound very, very familiar because they are very similar to what you require in either joinder or consolidation cases. So first is you need to have that valid arbitration agreement demonstrating consent to arbitration. But then we need to think about, is there any implicit consent or silence regarding the large scale proceeding? And the way that we decide what somebody has implicitly agreed is to look at the surrounding law, the choice of arbitration rules, other elements in the contract, etc. So it is relatively straightforward for an arbitrator to figure out implicit consent. You need to have identical or nearly identical language about the type of arbitration, meaning where is it going to be, what rules will apply, what's the governing law. And Simon talked a little bit about this. It is very difficult to have different arbitration provisions all put into one process because somebody's going to have a process that's in violation of their agreement. Fortunately, at least in the United States, many consumer arbitration agreements are exactly the same as each other. And that's why it is easy to put them all together in one class arbitration. Class arbitrations in the United States have had dozens of parties, maybe 12, or 20, 30 people, or they can have hundreds of parties, or even thousands, or even tens of thousands of people. So it can be quite large. But technically or legally, if it's all the same claim, the type of legal claim, then it's not that difficult to deal with. To have large-scale arbitration in the United States, at least, you cannot have a waiver provision. This is a line that says the parties to this agreement waive or give up their right to a class or collective proceeding. The United States Supreme Court, unfortunately from my perspective, has agreed that this is proper in the consumer setting, in the labor setting and in the antitrust setting. So that means that American parties do not have the ability to band together to bring a lawsuit if there's an arbitration provision and one of these waiver provisions exist. There are still cases that arise on a class basis in the United States, but the three Supreme Court cases from starting in 2010, and I will not list them, have cut down the number of class arbitrations significantly. Interestingly, there was a case literally just about a few months ago, and I was reading it for another purpose, called Car Pick and Carnival PLC, the Ruby Princess. If you I don't know how much the rest of the world was noticing, but we had a cruise ship that came into Australia right at the beginning of the pandemic, and unfortunately, many people were infected. About 28 people died, and a class action was brought here in Australia. And some of the parties were from the United States, some were from England, and the United States parties had a waiver provision. So the Australian court had to decide whether that waiver provision was valid. It indicated that it was not going to incorporate the US terms and conditions, so it kind of avoided the issue. It did say on one type of claim that the waiver looked valid, meaning appropriate and enforceable, but on another claim, a consumer rights claim, there wasn't enough facts. So the question is still open in Australia, but it is really, really very interesting to people like me. A question often arises whether you need to have judicial forms of large-scale relief before you can develop class or collective proceeding. It's helpful, but it's not necessary. And I know I'm getting very close on time, so I will go through my slides mostly to get them up so that I believe this is being recorded so that people will have them visible. Some of the advantages and disadvantages of large-scale arbitration are listed here. The key thing to remember is that class proceedings can injure the procedural rights of the parties because the details are being blunted. That essentially, because you're putting these big groups together, both the plaintiffs and the defendants are not able to argue their strategy specifically. However, there may be sufficient benefits that procedural irregularity is considered appropriate. When we talk about the Seatac rules, there are no specific provisions that will help us, but we can argue by analogy. These are the provisions that we look at. And as you'll see, the joinder and consolidation provisions are here because large-scale arbitration is just, in my mind, a particular type of joinder or consolidation analysis. So much of what we've said before will kind of carry on here. If you have any questions, I'm happy to take them at the end of the session, but I will hand off to my next colleague.
Thank you. Thank you so very much, Professor Strong, for taking our discussion to the next level. So having discussed joinder and consolidation in a potential several proceedings, we are looking at larger scale, class, collective and mass arbitration proceedings, all very complex topics. And we will come back to you and later during the Q&A session. Now, please allow me to move on to introduce our last speaker of today's panel, Mr. Brett Wang. Mr. Brett Wang probably needs no introduction here. Nevertheless, please allow me to very quickly introduce Brad. Brad holds position of managing counsel that leads the case management teams of China, Seatac, Hong Kong Center, and China Maritime Arbitration Commission, Hong Kong Arbitration Center, the CMAC, Hong Kong, both of which are the corresponding first and only overseas branches of Seatac and CMAC. Brett's responsibilities include supervising case management teams over administered arbitration cases and answering queries from parties and their counsels before, during, and after arbitration that are under the Seatac or CMAC rules or related proceedings. So, Mr. Brett Wang, it's over to you.
Thank you,
Thank
Fan.
you.
Can you hear me, and can you read the slides?
Yes, very good. Thank you.
Thank you very much. Multiple contracts, consolidation, large-scale arbitration, or joinder, as the previous panel have discussed, are instruments or tools that we developed to enable to make more disputes resolved in fewer arbitrations in an expert of less costly and more efficiency. I understand from Lu Fei and Liu Fei that more than 6,000 people are watching it online at the moment. And so I have concerns that some of you might not have the idea or have the practice, what those terms really mean, how to apply those terms in your dispute resolution process. So let me give you a lifelike example, which has nothing to do with legal aspect. I randomly pick up an example that I thought about 10 minutes ago. Say I'm walking on the street. And I want to buy a cup of coffee. And I walk into the supermarket and I purchase this cup of coffee. Let's call this whole process an arbitration. Okay, that's an arbitration. Now, I'm walking on the street. I want to drink some coffee. I want to know that Dr. Yang Fan also wants to drink some of the coffee. So I decided to walk into the supermarket, and I'm stunned by how many choices I have in the supermarket. And with respect, because I respect Dr. Yang Fan, I wanted her to also have a say of the flavor of the coffee before I make a choice. So I gave Dr. Yang Fan a call. Do you want to join me in the supermarket so we can buy this cup of coffee together? So that's a joinder in the most rough term. Okay, that's joinder. Say I'm walking on the street. I want to buy a cup of coffee and I want to have some honey in the coffee. Okay, then I'm walking to the supermarket. Before I walk into the supermarket, I have two options. I can buy this cup of coffee, get it checked out, and walk into the supermarket again and buy a cup of honey and check out again. So that's two separate arbitrations. Okay, that's two separate arbitrations. What I can also do instead is that I walk into the supermarket and decided to buy this cup of coffee and this cup of honey in one buy, in one purchase. So that's multiple contracts. That's what we mean by triggering multiple contract provision in Seatac rules for an arbitration. Now, say I'm walking on the street. I want to buy a cup of coffee. I go into the supermarket and I saw the cup of coffee there. But what also fascinates me is also there is a cup of honey that is on discount that I want to buy as well. Okay, together, I can buy them separately. Again, I can buy them separately. I can buy this one, leave out, purchase it and leave the supermarket and come back for this bottle of honey. Or I can buy them together. This is consolidation. Say I'm walking on the street. And I want to buy a cup of coffee. And that's not just it. I also post my intention on WeChat 朋友圈 and telling every colleague of Seatac that I want to buy a cup of coffee. And that attracts great welcome because 20 of my colleagues say, hey, Brad, why don't you also bring me a cup of coffee? So I walk into the supermarket and I buy 20 cups of coffee. So that's one of the ways to look at large-scale arbitration. I understand that this is a an advanced idea of arbitration nowadays, that a pioneering idea of arbitration nowadays that hasn't been developed in multiple jurisdictions. So I just have an attempt to define this term. Professor Strong may correct me if I'm wrong on this. So those are like very lifelike examples of those instruments that are used in nowadays commercial arbitration. Again, those are designed to make dispute resolution happen with fewer arbitration cases. Now I can end here, but if I don't want to bore you this afternoon, so I'm going to, if I may, show you a scenario which I script on real life arbitration cases. So I want you to spend the rest 6 minutes to look through what's been happening around the person, a middle-aged man called Ling Tao, and he has been dealing or troubling with a couple of disputes that's not easy to resolve. So here we go. Okay, here we go. So Ling Tao is 41 for the purpose of this seminar. He's 41. He's newly appointed CEO of a Shenzhen company, Shenzhen Giant. He recently signed a purchase and sales contract with a Schmitz company called Rhodia. And the contract is made for the purchase and sale of 120 latest model of drones. Okay, after a couple of installments paid by Rhodia, now the drones are received by Rhodia. However, Ling Tao was emailed by Jim Brown, who is the COO of Rhodia, that due to a new regulation that made known to Ling Tao, that made known by Jim Brown and the board of Rhodia, that recently several new licenses were required by Rhodia in order to resell the drones to end users at Switzerland. So Jim Brown, who is the COO of the Rhodia, requested in the email that Ling Tao should provide additional technical and business information and request a late settlement of the last 40% of the contract price. So that's dispute 1. Ling Tao was also reported by his sales representative at the Shenzhen company, Shenzhen Giant, that Rhodia, unprecedentedly, which has never happened before, has not settled several other purchase orders, old purchase orders made between Shenzhen Giant and Rhodia. These contracts pretty much involve products of all the modules of drones and their components. For the purpose of this seminar, all those contracts involved have a standard Seatac Hong Kong arbitration agreement included in all those contracts. Now, before we go any further, let's jump to the conclusion here first. If Ling Tao considers the option of settling all the disputes mentioned above in one arbitration at Seatac Hong Kong, Shenzhen Giant may initiate a single arbitration concerning all those disputes it has with Rhodia by relying upon Article 14 of Seatac arbitration rules and start arbitration in one case to settle all those disputes. So that's multiple contracts. What does Seatac arbitration rules say about this situation? Now, for those who don't often get involved in arbitration, if parties agree to submit their disputes at Seatac Hong Kong Arbitration Center, the default arbitration rules to apply is Seatac arbitration rules. So if you agree arbitration at Seatac or Seatac Hong Kong, and if you want to rely on on how we conduct multiple contracts in one arbitration, you look at Article 14 of Seatac arbitration rules. Article 14 of Seatac arbitration rules says the claimant may initiate a single arbitration concerning disputes arising out or in connection with multiple contracts. So basically, the claimant, the Shenzhen Giant, you may initiate one arbitration. But if you want to do that, you need to do that at the beginning before submit your disputes to us. You initiate one single arbitration. So that's what I meant in the previous example. I walk on the street and I have two things in mind to purchase. Then I make a decision. I walk into the supermarket. That's what I meant. So you can initiate a single arbitration here.
My apologies, Brad, may I interrupt here? Would you be so kind to just use the play PPT so that the audience can see your PPT properly? I think I've received some messages saying that they cannot see your PPTs.
Okay.
Maybe because, yeah, great, that's it. Thank you.
Thank
Please,
you.
apologies.
Sorry
yeah.
for the inconvenience. So yes, you can do that, but there are conditions you have to consider to be met in order to trigger Article 14. And the conditions are provided below. And note that I put in red, there's an "and" word here, meaning that you have to satisfy all the conditions stipulated under Article 14 to initiate an arbitration for multiple contracts disputes. Firstly, the contracts shall consist of a principal contract and its ancillary contracts. That's one way. Or the other way, such contracts involve the same parties as well as legal relationship. That's the first condition. Second condition, the disputes arise out of the same transaction or the same series of transactions. And lastly, the arbitration agreements in such contracts are identical or compatible. Let's look at the case that I just provided concerning Lintao. Firstly, there have been the same parties contained in the dispute, namely Shenzhen Giant and Schmidt's company, Rhodia. Secondly, the disputes contained belong to the same series of transactions, namely the purchase and sale of joints and their components. Lastly, the arbitration agreements are the same, identical. They all point to the Seatac Hong Kong Arbitration Center. So that is an example of triggering Article 14 to resolve Shenzhen Giant's disputes with Rhodia. We may end here, but however, in real life, things may get trickier. That's hardly the part or the concern of the arbitration institution like us, because behind the scene, whether or not you want to trigger this article is where commercial decisions meet legal considerations from the side of the claimant. So I can make this story more interesting by just providing you some fictional considerations by Lintao. Lintao may consider, oh, are we there yet? Are we there at the stage that we have to resolve all the disputes in one arbitration? If Lintao, he as the CEO, is not responsible for the previous transactions, he may not have, at that stage, have too much knowledge what was really going on for the non-payment of previous contracts. So does he have a good or strong case or what? He's not that sure. How will those multiple arbitrations affect our year-end financial report and my report as new CEO? Look at the case, he's newly appointed CEO. He has a lot to think about. The previous transactions were negotiated by my previous competitor for the CEO role, Wang Gan. Okay, there's another person, maybe a sales representative who was competing against Lintao for this CEO role. So the previous transactions were involved with this one. So Lintao as the CEO, does he want to trigger an internal war against Wang Gang in this company? Right, so it's that's what I meant by where commercial considerations meet legal considerations. There are more stories behind, and that's, I think, one of the reasons that make lawyers' life interesting. You need to dig out those information and make a comprehensive analysis and make a final decision. Now, Lintao's legal team may consider the cost of having multiple arbitrations or having one arbitration. If you use the Article 14, according to our previous experience, if you want to settle all the disputes in one arbitration, and I give you an estimate here, so at a later stage you can take a look, it costs significantly less, and it if used appropriately. Another rising consideration by the parties of using multiple contracts to resolve a serious transaction also has taken into this consideration, which is repetitive nomination of the same arbitrator. Say if you have multiple arbitrations and you want to have them separately, there is a practice where some lawyers would repetitively nominate the same arbitrator. And that arbitrator may have multiple nomination by the same party. So that may have the concern of his position as an independent and impartial arbitrator if later arbitration cases arise, because he or she as the arbitrator may have to disclose that that background, that one party has been multiply select him or her as the arbitrator, and that might trigger some procedural issues, especially for the later arbitration cases. That's one of the considerations of the legal team. However, if you want to start one arbitration, so that's one appointment instead of multiple appointments of the same arbitrator. Another consideration from the legal team might be the conciliation in the process of arbitration. In Chinese, we say 调解, 仲裁中的调解. So if you start one arbitration, let's say for the latest module, the latest order dispute, you start that arbitration. Then Lintao entered into the negotiation stage with the Erodia. And what if they want to settle all the disputes in this negotiation and come up with a final determination by the arbitrator? Now, if Lintao only initiated an arbitration for the latest module or dispute, in theory, the arbitrator may issue what we call conciliation statement, a 调解书, instead of an arbitral award, because technically, 仲裁中的调解 arbitration, conciliation in the process of arbitration, whatever you have conciliated cannot go further beyond what has been brought before the arbitral tribunal, if you want that arbitrator to reach a consent award. Otherwise, that may go beyond may be argued to go beyond the scope of arbitration, unless parties agreed and they arranged the whole procedure all over again. But if you started all the disputes in one arbitration, technically, if you go to the process of negotiation and you reach an agreement and you want a consent award, that arbitrator can do that without the need of having to have a conciliation statement rather than arbitral award. I hope I explained to you clearly. But if you have questions regarding this point, I'd be more than happy to explain in greater detail. Now, there are several other considerations from the institution's perspective, and not using Lingtao's case. We have, for us, the decision we need to make is whether or not to allow you as the claimant to bring multiple contracts into one arbitration to resolve the dispute. The first consideration is whether those contracts are compatible to be resolved in one arbitration. Nowadays, in practice, we tend to relax a little bit more to stretch what's being explained in paragraph A and B to make it more likely that we will accept a party to trigger Article 14. Say technically, for example, you may argue a hotel operation and management agreement and hotel software usage agreement might of two different types of contracts. And some may argue one is not the ancillary contract of the other. But in real life, we may accept disputes of those kind in one arbitration case. Similarly, medical equipment, sale and purchase, medical equipment service contract are often brought together in one arbitration case before us. What's still being a little bit hardcore here is whether or not the arbitration agreements contained in those separate contracts are compatible or not for us to have it all in one arbitration. Say, for example, here, if one of the contracts say arbitration at Seatac Hong Kong Arbitration Center, and the other say arbitration in Hong Kong, now the latter is an ad hoc arbitration agreement. I don't believe those two are compatible arbitration agreements for one arbitration to resolve the disputes. A more trivial, more technical example I have given is here. It says arbitration at Seatac Hong Kong, let's say one contract, and the other arbitration agreement says arbitration at Seatac Hong Kong, and each party shall nominate an arbitrator, and two party nominated arbitrators shall nominate the presiding arbitrator. Now, if you are familiar with Seatac arbitration rules, the presiding arbitrators are usually firstly discussed. There's a possibility parties may nominate a presiding arbitrator upon their own agreement. But if they fail to nominate a presiding arbitrator, the Seatac chairman shall nominate the presiding arbitrator on behalf of the parties. So arguably, I leave with a question mark here, whether or not those two arbitration agreements are compatible. Well, those need to be tested in real cases, and I look forward to hear brilliant submissions by the parties, or by the lawyers, actually. Now, those are Article 14, multiple contract scenario. Now let's go one step further and look at consolidation. Let's go back to the Lingtao story, okay? So that was only one of the issues, the purchase order issues that has been bothering Lingtao. About 3 years ago, Han Mei and Li Lei, who are two shareholders of Shenzhen Giant, is transferred 14% of their shares to two investors. One is Capital Brown, and the other is the ZQ funds, for the injection of certain amount of capitals. Han Mei and Li Lei each entered a share purchase agreement and a repurchase agreement with the investors. According to the annual finance reports last year and the year before, the company neither reached its goal of annual growth rate of 7%, nor a valuation at 0.28 billion RMB, which satisfy the condition that triggers repurchase of the shares. So the company did not grow as expected. Now the investors want the money back. Okay, there are two investors, there are two shareholders that are involved Lintao is a CEO that is troubled with the situation. So that's the scenario of this case. Now, one of the investors filed an arbitration request against one of the shareholders. Lintao, as the CEO, decided to have a meeting for all the investors involved and all the shareholders involved, partly to avoid the second arbitration, which contains the other investor and the other shareholder. Now, to Lintao's surprise, the second arbitration also took place. Now, to give you some extra background information to make it more plausible in a real-life arbitration, say Lintao and Han Mei, they are actually related. Those two shareholders are related. For example, they might be husband and wife, they might be son and daughter. One of the shareholders is actually taking the share on behalf of the other shareholder, or be entrusted by the other shareholder to stand in the company in the name of shareholder. In Chinese, 代持，一位股东为另外一位股东代持, which is often the case in a lot of situations. Now, the two investors actually are in this scenario, one of the investors is the major shareholder of the other shareholder. So they are connected some way. Now we're at the stage, the first arbitration has started and the tribunal has been formed. I noticed that there have been an online question. In this situation, is there a possibility for consolidation? The short and simple answer is yes, but conditions are to be met. Now, Lintao, after consulting with the legal team, understands there's a possibility that still the second arbitration case can be consolidated into the first arbitration case by relying on Article 19 of the Seatac rules. Am I running out of the time? Just Fan. Okay, yes. Then I'll keep it simple. So maybe I'll finish with this slide and I'll skip the large-scale arbitration. Now, Article 19 of Seatac arbitration rules says at the request of a party, which means either shareholder or investor in my given example, Seatac, so the decision-making body is the arbitration institution. Seatac may consolidate two or more arbitration pending under these rules into a single arbitration. And I omitted a lot of conditions because those conditions are interchangeable because we use the word or to connect all the conditions. So you don't have to meet them all. As long as one of the conditions are met, there is a possibility. So what I still leave on this, what I still have left on this slide is all the parties to the arbitrations have agreed to consolidation. Let's say all the parties, they have been in amicable situation and they want to use one arbitration to resolve all, and that may lead to an arbitration, one arbitration. But under that arbitration, if you look at paragraph 3 of Article 19, it's always, unless parties agree otherwise, the arbitration shall be consolidated into the arbitration that was first commenced. That means, okay, the second case will be consolidated into the first case. And you shouldn't forget the fact that the tribunal has been formed, meaning that the second investor and the second shareholder will not have a say in nominating their own arbitrators. But again, if parties agree, we can make it happen. Due to the constraint of time, I'll finish by just saying, we from the institution perspective, when we consider whether or not to consolidate cases, we look at parties' opinions. We consider that's the fundamental consideration. If we look here what parties say first, and we also consider whether or not, if by just doing the exercise, are we putting on too much detriment to the case, to the first case, that low-hanging fruit? Are we putting detriment on that case? Are we delaying that case? I think Simon has also mentioned the significance of the formation of the tribunal. how do we reconcile with that point in the process of consolidation? Because if we look at the other side, what if we just didn't agree on any arrangement of that? We have two separate arbitrations that would arguably, we would say, have no procedural issues that parties may raise, two completely healthy arbitration cases. But if we are here struggling to reach a decision that is in favor of consolidation, we may have some procedural issues that we need to seriously take into consideration. So I will end here, and I'll forget the last point, which is about large-scale arbitration. Let's say Ling Tao has said, or joined the gym, that gym just maltreated a lot of gym members like Ling Tao, and they decided to all go together and target that gym.
Okay, thank you very much. Thank you, Brett. Really appreciate it. I apologize for not interrupting Brett a bit sooner. I have a good ground, if I may say so. So I double checked our program and I realized there is no time set down for the closing. So I thought, oh, that would be a good opportunity. And especially when Brett's topics are so interesting, using a fictional story and explaining the, various scenarios that when all these interesting concepts, issues that we discussed here may arise in practice. And I think that it's fascinating when we also look at even when Brett's comments on the Seatac rules, right? So it seems to me the Seatac rules, Article 14 on the multi-contract arbitration, all parties have to be the same. Otherwise, that's already a no-go. So you have to have all the same parties to trigger the Article 14 for the multi-contract arbitration. And then for Article 19, Brett just referred to, you have to get consent. Otherwise, there won't be consolidation. So it looks like not so easy in a way for parties who are considering these processes. And that may lead to my executive decision, if I may, to invite Simon to comment briefly on what would be the grounds for challenge an arbitral award on the basis that a case has been wrongly consolidated. And if we still have time, we will see if we can answer a few other questions. But otherwise, please, Simon.
Yeah, that's an interesting and debated question, because as I mentioned, and also Brad mentioned, and Stacy touched upon, it's quite delicate and even complex getting right the question of whether or not it is possible to consolidate cases, particularly where there are multiple different contracts involved. But nonetheless, that's a decision that gets taken at the start of an arbitration, either by an arbitral institution or, depending on the rules and mechanisms, by an arbitral tribunal. And what's debated is whether or not that decision is of a kind of administrative nature or whether it is of a jurisdictional nature, which arguably it's jurisdictional because it assumes something about the way that the parties have consented or not to that type of arbitration. So if a court takes the view that it's a jurisdictional decision, then that decision can arguably be challenged on the basis of the rules in the arbitration law that allow any jurisdictional decision of an arbitral tribunal to be challenged. And that means in almost every jurisdiction, a de novo or full review of the decision on jurisdiction. But if it's construed as a more administrative decision or a more procedural decision, and it cannot be challenged on jurisdictional grounds, but it could potentially be challenged if the parties' agreement on the mechanism for consolidation was not followed properly. because we all know that the New York Convention and any arbitration law allows an arbitration award to be challenged where the parties' agreement on procedure was not properly followed. And so I think your question, how can a wrong consolidation decision be challenged? Well, there are two potential ways, either for breach of the jurisdictional requirements or for breach of the procedure agreed by the parties. And which one of those a court will adopt might depend on the court's particular practices. Thank you.
Thank you, Simon. And I think that you also sort of, in a way, answer one of the questions posted on the Q&A here. I think one participant was asking why that consolidation decision is that administrative. So I suppose the answer is that it really depends. It's not necessarily be considered as an administrative decision. It depends on the court's views and the circumstances of the case.
Yeah.
Is that so? Yeah.
And I think it's, I didn't see the question. I apologize for that, but I mean, I think it's a very interesting point, and it's unfortunately or fortunately one that has very rarely come before courts, and so it's actually not very clear which way it goes and whether a court could, under the New York Convention or a law that's been inspired by it, could in fact effectively overturn a consolidation decision. Very interesting point.
Yep, absolutely. Thank you. And may I also invite, if all the other speakers, panelists, and moderators still online, just to show, open your video again. And let's all thank the audience today and thank the organizers and our sponsors and for what a very interesting discussion that we had here. Is there any other comments or anyone would like to make some final remarks? Nope. All look tired. All right. And thank you all again. And with that, please allow me to close the discussion here today. And you have all the names of our panelists and speakers. So if you have further questions that you would like to ask, please feel free to reach out to them. I'm sure they will be happy to have some further discussions in due course. All right. And with that, thank you all. And good evening and good afternoon, good morning there. Thank you. Bye. See you next time.
Yes, Fan, thank you. Thank you for closing the episode today. What I would supplement is only that let's look forward to the next 3 episodes, respectively in April, May, and June. Goodbye. See you.
Thank you. See you soon. Much appreciated. 谢谢大家，辛苦。